Hi, I'm Beth Wanless, Local Government Affairs Director at Illinois Realtors, and I'm here today with Caroline Elmendorf to discuss criminal background screening processes in prospective residents. Thank you so much for joining us in our conversation with Caroline Elmendorf. She's a Senior Compliance Officer for the Bozzuto Management Group, who works with more than 2,500 employees. The Bozzuto Group is a diversified real estate company that focuses on development, construction, property management, and home building. Prior to joining the Bozzuto Group in 2007, Caroline worked in private practice and for the Department of Justice. Caroline has been an attorney for more than 25 years and currently handles all fair housing issues at her company. In addition, she develops policies and procedures to ensure that Bozzuto properties abide by the letter and the spirit of the Fair Housing Act. Caroline received her bachelor's degree in political science from Princeton and received her law degree from George Washington University. I've had the pleasure of working with Caroline for many years on property management related issues, and I can tell you she's a wealth of knowledge. Thank you so much for being with us today, Caroline.
Thank you, Beth.
Caroline, can you give us a brief background on the guidance that was published in spring of 2016 that was set out by the Office of General Counsel by the Department of Housing and Urban Development, and that's just pertaining to housing providers and criminal background screening?
Certainly, yes. HUD's issued criminal background screening guidance stating that the way many members of the housing industry are conducting criminal background screening can actually be a fair housing violation under something called disparate impact theory. This finding was based on the disproportionate number of African Americans and Hispanics who are involved in the criminal justice system, being arrested and incarcerated at higher rates than Caucasian people. Mm-hmm. And so HUD said, under disparate impact theory, this can be a fair housing violation. Now you might ask, wait a minute, criminal background is not a protected class under the Fair Housing Act, and criminal background screenings are applied across the board to everybody. They're facially neutral, so how can that violate the Fair Housing Act? Well, under disparate impact theory, a housing provider can violate the FHA even with facially neutral practices and with no intent to discriminate if the end result is that the practice has a disproportionate effect upon protected classes. And disparate impact theory was actually embodied in a regulation issued by HUD in 2013 and then reaffirmed by the Supreme Court's Inclusive Communities decision in 2015. So we know that's the law of the land. And HUD said because of the disproportionate number of African Americans and Hispanics in the criminal justice system, when you applied criminal background denials to all applicants, this will have a greater negative effect on these protected classes. So the guidance said we need to change how we're handling criminal background screening. We need to do things a little bit differently. For example, we shouldn't have across-the-board bans on everybody who has a criminal background. In the past, a lot of housing providers would have a box on their application and it said, asking, have you ever been arrested? Do you have any criminal convictions? And if you said yes, well, that's it. You couldn't move into the community. Now HUD came back in their guidance and said, no, that's not appropriate. You should not screen for arrest, for example, and you should not deny people across the board for any type of conviction. You need to have a more narrowly tailored process that focuses on convictions that would impact the safety of residents in the community. HUD also said that we can't have these incredibly long look-back periods where we're, again, excluding people for crimes that occurred, 25 years, 99 years in the past. A lot of housing providers, again, would have 99-year bans for any criminal conviction. Now HUD is saying you need to have a sliding scale of look-back periods depending on the severity of the crime. So this will have a big impact on the industry and how we conduct criminal background screening.
Okay, so this is guidance, not a regulation or law, correct?
That is correct. Federal agencies are allowed to issue guidance documents that they're not regulations, they're not legislation. They're statements of how the agency interprets an existing regulation or legislation. And so because they can be issued by the agency alone, they don't go through any kind of notice and comment period that's required for regulations. So they're issued without the input of the different players that can be affected by the regulation, by the guidance. Guidance documents do not have the effect of law. A court does not have to enforce a guidance document. On the other hand, they typically are given great deference by the courts. And because they are a statement of how the agency interprets the law, we need to take them very seriously.
Right, definitely. Now, the guidance treats an arrest and conviction completely differently. Housing providers cannot look at the arrest history at all, correct?
That's correct. In this country, we do have a principle that says you're innocent until proven guilty. And so HUD's guidance states that we really should not be denying people for arrest records. And as a matter of fact, in my company, we've not been screening for arrest records for several years now. And HUD indicated that we should focus on convictions. And again, convictions for dangerous crimes. So there might be some types of crimes that we wouldn't even screen for anymore that don't have an impact on safety of individuals or property. Sex, for example, maybe some financial crimes or something like bigamy. That might be something you wouldn't even have on your list of screening criteria.
Interesting. How many years can you look back at someone's criminal record? I know it mentions 7 years in the HUD guidance in the footnotes, but could a provider see if a prospective resident was convicted of a violent crime 20 years ago or 10 years ago?
Well, that question leads us into the proverbial gray area for which we don't have clear answers. And again, as you mentioned, HUD just alluded to a 7-year look-back period in a footnote. The 7-year look-back is nowhere embodied in the federal law. On the other hand, if you want to have a very conservative approach under the guidance, of course, you could have a maximum look-back of 7 years, and then a lower, even a shorter look-back period for less serious crimes. Why 7 years has been suggested by HUD and other entities is that studies have shown that an individual's recidivism rate falls back to 0 after 7 years. They're no more likely to commit a crime after 7 years than a person who's never had a criminal background. So that's why 7 years is looked to as an appropriate look-back period. On the other hand, that is not the law. And if a housing provider says, well, for certain serious crimes, I really won't feel comfortable unless I impose a longer look-back period, that might be appropriate as well. We really have to wait and see how the guidance plays out in the courts.
Interesting.
Yeah.
Does the guidance specifically tell us what types of convictions a housing provider can and cannot deny?
No, the guidance does not provide a specific list of which convictions are deniable and which aren't. However, it does say the housing provider should focus on dangerous crimes that could have a negative impact on the safety of residents at a community. So I think that would be looking at major felonies, of course, and felonies involving weapons, assault, any kind of physical activity. Those are the ones we should focus on in terms of how we look at applying denials to applicants across the board.
What about convictions involving property damage or multiple convictions with property damage?
I think those are also relevant too. I mean, we have to be concerned about our residents and also our residents' property, their vehicles. We have to be concerned about the property that our housing providers own. So I think looking at a history of property damage, robbery, is definitely a viable option as well.
Now let's talk about the screening process. When in the tenant screening process should a housing provider run a criminal background check? Does it matter?
Well, when you run a criminal background check, it does matter under the guidance. The criminal background check should be run the same way for all applicants. At my company, we apply criminal background screening to all occupants over age 18. And of course, it needs to be done at the beginning of the application process. There's a suggestion in the HUD guidance that the criminal background screening should be conducted after the credit screening is done. So it suggests a bifurcated process where an applicant would get approved for their credit and only then go through the criminal screening. However, that type of process can be very unwieldy, time-consuming, and costly to housing providers and applicants.
Interesting. How do property managers and housing providers take steps to be in compliance with the guidance? What can they do right now?
Right now, if a housing provider wants to become in compliance with the guidance, or at least reduce their risk of liability for violating the Fair Housing Act for criminal background screening, what they should do is stop screening for arrests. They should meet with their third-party screening company and discuss the criteria that is being used for screening applicants, and also the look-back periods. It's important to have a scaled look-back period that changes depending on the severity of the crime. And then they should look at what crimes are being screened for and make sure that the crimes are ones that are related to violence and property damage at a community.
Okay. What about if you're brand new to the property management industry and you're starting a management company? What do you need to do when you're just starting out to be in compliance?
Well, if you're just starting out and you want to be in compliance with the Fair Housing Act criminal screening guidelines, it's important first that you look at your application that you're using. I would remove questions about criminal background from the application. And then I would, again, meet with the third-party screening company and review the criteria that are being used to screen. And then I would look at something we haven't talked about yet, which is the appeals process. Mm-hmm. The HUD guidance suggests that housing providers should allow applicants who have been denied for criminal background be given an opportunity to appeal that decision by presenting information related to the age at the time of conviction, extenuating circumstances surrounding the conviction, and then evidence of rehabilitation after conviction.
So going back to the convictions and someone with a conviction history, is there a type of criminal conviction that can be automatically denied without any risk of liability?
Yes, there is. The HUD guidance states that housing providers can deny anyone who has a history of manufacturing and distributing controlled substances. That doesn't mean housing providers have to deny all applicants for that basis. They can include that in the list of crimes that they will allow applicants to appeal a denial, but they are not required to do so.
What about sexual offenders? Are they an automatic denial, or can they be an automatic denial?
Well, I would not recommend that, actually. At one point I might have done so, but after investigating sexual offender registries, I found out that different states have different criteria for putting someone on a sexual offender registry. In some states, someone automatically gets put on a registry for public urination. And so I think it's important to not have an across-the-board exclusion for being on a sex offender registry, and instead develop the criteria for sexually related offenses.
Okay, so this may go back to the HUD guidance, and what it suggests housing providers do is take convictions on a case-by-case basis and look into the crime and see what actually happened.
You make a good point, Beth, but what HUD says is the housing provider doesn't have to analyze the conviction originally on a case-by-case basis. It only needs to do so if the applicant is denied and then appeals that denial. Then HUD says we should allow the denied applicant an opportunity to submit information regarding extenuating circumstances at the time the crime occurred, their age at the time a crime occurred, and evidence of rehabilitation after the crime occurred. And if an applicant is denied and decides to appeal that decision, then they get to submit all this information, and then we need to look at the information and review it on a case-by-case basis. And in fact, the District of Columbia has enacted a law that reflects the HUD guidance and has adopted a procedure that all housing providers in DC have to follow that includes an appeals process.
Caroline, can you share some examples of types of convictions that you would deny at your company?
Sure, Beth. There's several types of criminal convictions that we would deny an applicant for. For example, of course, murder, sexual assault, assault with a deadly weapon, carjacking, armed robbery, I mean, there's several more, of course, that we would deny someone for and apply a look-back period to.
Great, that's helpful. So you mentioned denying an applicant based on a conviction or a conviction history. Can you talk more about the appeals process for that?
Sure. You know, New York State has developed a really interesting questionnaire to be used at affordable communities in New York. And I think that's a great resource for housing providers to use in contemplating implementation of an appeals process. Again, the whole concept of an appeals process is only in guidance. It's not law. And not everybody's ready to go there yet, because an appeals process itself can lead to fair housing concerns, right? It brings a level of subjectivity to the whole process. So many housing providers are reluctant to go there. And then it involves so many other issues like timing, who's going to handle the appeals process. So it really involves a lot of thought to develop a very well thought out appeals process for folks who are denied. In any event, New York has developed a really interesting questionnaire that can be used in evaluating appeals in affordable communities. And it starts with a first question, you know, has the conviction related to manufacturing and distribution of illegal substances? If yes, well then, done. The person is denied. Next question, is the offense related to a dangerous crime? If no, then the person can move in. If yes, then we continue the inquiry. Then the questionnaire goes on to ask, were there any extenuating circumstances at the time of conviction? What was the age at the time of conviction? How many years have lapsed since the conviction? And how many years have lapsed since the person was released from incarceration and the time of application, which I think is a very good point to look into. Has a person had a time to be rehabilitated since they were released from prison? And then the questionnaire goes on to list a host of factors to be looked at with respect to the rehabilitation piece. Has the person obtained gainful employment? Do they have a good tenancy history elsewhere? If they're not employed, have they taken other positive steps to be part of the community? Are they obtaining an education or some type of licensing or certification? Are they doing volunteer work? We could look at other factors. Does the applicant have any letters of recommendation from other community members, and how many letters do they have? So it really walks you through the appeals process, and I found it to be a very helpful resource. And I recommend that other housing providers look at that if they're considering developing some type of appeals process. Another recommendation is that when an appeal comes in, that whichever individual or small group of individuals is reviewing the appeal, that they are shielded from any information regarding the individual's protected class. So their name, age, race are all concealed. And that helps further insulate the deciders from any claims of discrimination, because they won't know whether the person falls into any protected class categories, and it helps reduce bias.
So would you recommend that a housing provider or property management company look to that appeals process in New York as something to implement?
I would say maybe not lock, stock, and barrel, but at least look at that, at the questionnaire, and maybe develop your own questionnaire based on New York's guidelines. I think it's very helpful.
Great.
Yeah.
So let's talk about the screening companies. Can you rely, or can a housing provider rely on a third-party screening company to kind of maneuver the HUD guidance properly?
housing providers cannot rely on third-party screening companies to comply with the fair housing guidance from HUD. Housing providers are themselves liable for Fair Housing Act violations, and you cannot contract out your liability. So it will not be a defense for a housing provider to say, oh, well, the screening company did it wrong. Rather, the housing provider needs to take control of the process, meet with their third-party screening company, review the criteria, and establish the criteria that will be used in reviewing an applicant, and also look at the look-back periods. And the housing provider has to tell the third-party screening company which look-back periods to apply, depending on the type of conviction.
Great. Caroline, we covered a lot here. If there are 3 takeaways for a property manager, what would they be?
If a property manager just did 3 things, they would significantly reduce their liability under the Fair Housing Act with respect to criminal background screening. The first thing is not to deny people for their arrest records. Don't even ask about arrests. The second thing would be to eliminate blanket bans for a criminal background. Instead, housing providers should develop a more narrowly tailored process that focuses on violent crimes. The third thing is to have a sliding look-back period with greater look-back periods for more severe crimes and much shorter look-back periods for less violent crimes.
Caroline, a lot of policymakers implement laws to decrease barriers to housing. However, their policies do end up hurting prospective residents due to unintended consequences. What can the industry do to work with policymakers to better implement these policies so that it makes sense for everybody?
That's a really good question, Beth. A lot of localities are considering legislation related to implementing HUD's criminal background screening, and it's really important for housing providers and their local associations to educate local governments about how the application process works. A great example is what happened with the DC legislation, which requires a bifurcated application process. An applicant is supposed to go through the credit screening, and only if they get approved, then undergo criminal screening. The problem with that is that extends the whole duration of the onboarding process, and it adds to the cost for the applicant. Housing providers are not going to be able to eat that cost, so they're going to have to charge applicants for 2 sets of screening processes. And we have a lot of applicants that want to move in a very short time frame, and we won't always be able to let them do so with a bifurcated screening process. So I think that is something that the housing providers really need to educate local jurisdictions about. Another issue is that relates again to the DC law, is the DC law specified the DC crimes that an applicant can be denied for. The challenge with that is that we have applicants coming from many states around the country. And so now we've had to, again, slow down the application process and review each conviction to see if it matches up with the list of DC crimes that are eligible for denial. And so instead of being able to rely on a third-party screening company, we have to literally sit through and comb through someone's criminal records and make that determination up front. And that really can slow down the process, and it also becomes a privacy issue for the applicant. We don't want to have to look at their criminal records. We try to keep that information out of the picture as much as possible. That's why all of us use third-party screening companies. But because of the way the DC law is written, we have to scrutinize an applicant's criminal background before we issue a denial. So I think if we'd educated the local government more extensively about how this regulation would play out in real life, maybe they would have adopted a slightly different system.
Thank you, Caroline. That was great. I really appreciate you being here today with us. That was Caroline Elmendorf. She joins us from Washington, D.C. from the Bozzuto Group, and we were just discussing criminal background check screening and prospective residents. Thank you so much for joining us.